For decades, survivors of abuse in California's juvenile detention system have come forward to expose widespread sexual violence and institutional neglect. Riverside County's Probation and Social Services Department have faced numerous lawsuits and investigations in recent years, revealing systemic failures to protect children and youth in their care. In 2019, the county settled a lawsuit with the ACLU that accused the county's Youth Accountability Team program of creating a pipeline to prison for youth of color by criminalizing behavior like truancy and poor academic performance. Under the settlement, the county agreed to stop referring youth to that program. In 2018, Riverside County's top social services official resigned after reports that social workers have failed to investigate and report child abuse and neglect claims. Lawsuits accuse the department of ignoring repeated warnings and failing to protect vulnerable children from harm. These repeated failures highlight a pattern of negligence and misconduct across Riverside County agencies tasked with youth welfare and rehabilitation. Survivors of sexual abuse in juvenile detention centers like Riverside Juvenile Hall have the right to report abuse, file civil lawsuits, and access legal and mental health support services. While criminal charges can hold the individual perpetrators accountable, civil lawsuits allow survivors to pursue justice against the institutions and officials that enabled the abuse to occur. Survivors who suffered sexual abuse at Riverside Juvenile Hall may be able to file a civil lawsuit against the facility, the county probation department, or other responsible entities. Under California Assembly Bill 218, also known as AB 218, survivors of childhood sexual abuse under 18 at the time have until their 40th birthday or 5 years after discovering the harm to file a lawsuit, whichever is later. For survivors who were 18 at the time of the abuse, the law provides 10 years from the date of the assault to pursue civil action. These extended statutes of limitations give survivors the opportunity to seek justice, even if that abuse occurred decades ago. Through a successful civil lawsuit, survivors of juvenile detention sexual abuse may be able to recover damages for medical and therapy expenses, pain and suffering, emotional distress, lost income or earning potential, and punitive damages. While compensation amount varies, an experienced sexual abuse attorney can help evaluate your case and estimate potential recovery. Navigating the legal system after sexual abuse can be overwhelming. A trauma-informed attorney experienced in juvenile detention sexual abuse cases can guide you through the legal process, protect your rights and confidentiality, gather evidence and build a strong case, and advocate for justice and fair compensation in court or settlement negotiations. Working with a qualified lawyer increases the likelihood of a successful outcome and ensures survivors do not face the process alone. If you or a loved one experienced sexual abuse while detained at Riverside Juvenile Hall, you may be eligible to file a civil lawsuit. Our partner attorneys provide trauma-informed legal guidance and work on a contingency fee basis, meaning you pay nothing unless they win your case. Contact Helping Survivors to learn more about your legal rights and options for seeking accountability and compensation.